Good afternoon, everyone. Thank you for joining us today for the latest Irwin Mitchell virtual event. And our webinar today is on the topic of probate process changes, I guess. Took us all a little bit by surprise when they came in towards the end of March, just as we were entering the lockdown, and also some changes that have been made as a result of the situation we find ourselves in relation to inheritance tax. So just to introduce the speakers today. So myself, I am Gillian Coverley. I'm a partner and in the tax, trust and estate team here at Irwin Mitchell, and I am the chair of the internal probate technical committee here. I'm joined today by John Bunker, who, as you can see, is a consultant solicitor and a chartered tax advisor. And John is the perfect person to update us today, particularly due to the fact he has a couple of key roles, one of which, as well as being a solicitor here at Irwin Mitchell, is he has a couple of roles on some committees, the Chartered Institute of Taxation, Private Client UK Tax Committee, and he's also been representing SEP in work with the courts and the registrars about the probate changes. I'm sure John is going to enlighten us on some more of that as we go through the webinar today. I just wanted to say as well before we start that a couple of people did submit questions prior to the webinar today, and I will deal with those at the end of the main slide deck. And if anybody wants to submit a question as we're going along, there should be somewhere on your screen, I'm hoping, a Q&A button. Please feel free to ask some questions and we'll either deal with those at the end, or if it's relevant, we will try and deal with them as we're going along if we can catch them in time. So please do feel free to submit some questions if you'd like to do so. So just to give a little bit of background, I appreciate that a lot of people on the call are probate practitioners and will be familiar with the probate process. But just to reiterate what we're talking about when we're talking about applying for probate, well, there's two aspects to it. One is obviously we need to fill in an inheritance tax return. We need to report to HMRC irrespective of the value of the estate. We also need to apply to the Probate Registry to actually issue the grant of representation, the grant of probate. That's a generic term that we tend to use. And that is to establish that the last will is the last will and to prove the last will, and also seek title to the executors or the people who may be able to apply under intestacy to give them title to administer the estate. So as we know, a grant of probate applies only to executors where there is a will, and the other terminology that's used is a grant of letters of administration if there is no will, so an intestate situation, or if there is a will but for whatever reason there are no executors, and this is known as a grant of letters of administration with will annexed. But we tend to use the phrase grant of probate to mean all of those three. I've just gone backwards, bear with me. So as we know, as with most legal processes, there's an increased push to digitalise the service and then computerise what we are doing. And as I said at the beginning, there was an announcement just at the end of March about this change to the probate process. It had been coming for a while. There's been online processes available for personal applications. There's been solicitors online that have been available for solicitors and others who are applying for probate for a little while. But these are more fundamental changes, which John is going to go into more detail on. We had previously a situation where we had to prepare oaths to be sworn by an executor, and that was to identify the last will, to identify the executors and the estate and the details of the lease. And that had to be sworn, which is a little bit cumbersome because it had to be sworn in front of a solicitor that wasn't the solicitor who prepared the document in the first place. About 18 months ago, that changed to being statements of truth, not oaths anymore. And the benefit there was that although the content of the statement of truth is pretty much the same as the oath, the statement of truth itself didn't have to be sworn, so it did make that step a little bit easier. So now we're on to the next step, to digitalise the process, to encourage us all to use an online application where it's possible to do so. So who can apply for probate? At the moment, there's two routes to do that. You either do it yourself or you employ someone who is either a solicitor or an other person licensed to obtain probate on your behalf. And obviously, probate itself, obtaining the grant of probate, is one of the elements of dealing with an entire estate. And as well as just dealing with the probate application at Irwin Mitchell, we can deal with full end-to-end estate administration work as well. So now I'm going to hand over to John, who will take you through, firstly, some inheritance tax changes as a result of the crisis we're in, and then the probate changes.
Thanks, Jill. Good afternoon, everybody, and it's very good to be with you. The first thing to talk about is some of these inheritance tax changes where HMRC have actually been quite sensible and responsive in dealing with the way we deal with accounts, and then the payment of inheritance tax, and there's one or two other changes I just want to mention. What they have done very sensibly is to say that in terms of inheritance tax accounts, I'm talking here about two forms of account, the IHT 400 for estate and the IHT 100 for trust. In signing those accounts, where a professional firm is acting for the executors or for the trustees, those forms can be approved by the client sort of over the email, and then we can send in on their behalf with an appropriate statement saying that it's been approved by the executors or trustees, and without the actual signature being needed. So we haven't got to send a form back and forth, get it actually signed by the clients, get it back, and so forth. That's a really sensible change, really helpful change. So where any professional is acting, it cuts out that kind of personal signature and pass back and forth. It means you've still got to get the approval of the client to the document, but at least it can be done via email. This doesn't apply to all tax forms. So if, for example, you'd done an IHT 400 and then you were getting to the end of the estate and you had to correct the account because there were some changes and perhaps some additional tax to pay, that corrective account would need to be signed by the executors themselves rather than just by the solicitors. If the executors have signed the original, then they need to sign the follow-up and so on. So there, but as far as it goes, it is really helpful, and it's a really good and sensible change. On the payment of tax, it's again very sensible. The recognition that checks are difficult. Actually, sending checks in the post and getting them banked is not easy either way. So whether it's us paying the tax, we can't now pay it by check, or indeed the revenue sending us a repayment if there is an overpayment of tax and we have to get a payment back, that can't be done by check either. So all of these payments will now be made electronically. I've noted here a few other points about the revenue, and first of all, they are exploring ways in which we can file accounts, that is for estates on 400 or the simpler form of IHT 205, to file them online. And in fact, this last week, we have been taking part in a pilot for that, and if we can get some of the issues sorted with HMRC, then that will be good. We can then get that done. The second thing is that there is now a new process with the IHT 421. That is the form which some of you will know, the revenue issue, or that we apply for, and then they stamp to say two things. They've received the IHT 400, and any tax we've paid on that has been paid. That now is being sent. When we send it in with the 400 to the revenue, when they have dealt with it, they send it on directly to the Probate Registry now by an email. And that is, it's a very sensible change to cut out a bit of the postal delay, but there will be an even more sensible change, which we'd love to see, and we are still working on this one, which is when you send that when the revenue send that to the Probate Registry, could they just also let us as professionals know that they've done that? It would be so simple, we think, and we are hoping that they will do that. It would be a very helpful thing because obviously one of the issues in the States, and I appreciate it's something which has caused concern a lot over the years, is the amount of delay and time things take. And very often the delay is not due to a professional sitting on the file. It's because we're waiting for something. Well, this is one of the points of potential delay when we're waiting for the revenue to come back to us, where it would really help to know they've got the account and they've received the tax. They are working to a time estimate that they will issue the 421 within 15 working days of receiving the account from us. That's their target, and they said they're meeting that in 95% of cases. Obviously, the 5% are the ones that we all worry about that cause us problems. They also have a time scale and a process issued for following up. What happens where there are issues on the 400 they need to take forward? And they are trying to, it's a brave new world of openness and trying to show that they are responsive, which is great. We hope that they can work on that a bit more. But the idea is that we get a better idea of how long it's going to take for each stage of the process. And then finally, on this slide, I wanted to mention the fact that the revenue are looking at other issues about how they can help us during the COVID-19 crisis. And there are cases where effectively the estate is illiquid. It's frozen because you can't get access to the assets. In some cases, the property market has disappeared. In some cases, property or investment values have fallen hugely. And in some cases, there is very little movement in the market. So they're looking at that to see whether there's anything else they can do. The problem there is that some of that would involve primary legislation. But just to say they are on the case, I was on a call with HMRC with my hat on as chair of the CIOT committee that I chair. I was on that call just about 10 days, 2 weeks ago, and they are looking at that, and we hope there may be some more movement on that fairly soon. Let's then go on to look at the probate changes. Now, if I think back 2 months, there were two things 2 months ago I didn't think I'd be doing. One was working at home under lockdown, but the other was spending a large part of my life thinking about the probate process. I had no idea the joys that were before me in terms of this whole probate process, which suddenly, as Jill said earlier on, happened, changed at just the time we went into lockdown. So I've spent a large part of the last 6 or 7 weeks of my life on this, and I put on this slide here at the bottom of the slide that this, the notes that I've got here take into account the very latest from the Her Majesty's Courts and Tribunal Service. I attended a meeting on Tuesday when all 4 probate registrars across the country, across England and Wales, attended, and I was representing STEP at that meeting. It was a second meeting I'd attended where we were looking at the details of how this was working. So I've tried to reflect in these slides that experience of what they're saying is happening, and so this is as much as you can from 3 days ago, straight from the horse's mouth. So I hope you'll find my comments helpful, and if you think there's something I've missed out, do come back with a question at the end. But it is very much a kind of work in progress, I think it'd be fair to say. I think there's been a lot of difficulties with this whole subject, and it's not been easy for anybody. But let's look and see. The fundamental thing is there's a whole new process about how people apply for a grant of probate. We are just coming to the end of an 8-week transition period. And this whole process is essentially about 2 things, as I've put in these 2 boxes here. To enable the probate registries to move to digital working across the country. And what do you know, absolutely fabulous, it has really helped in this crisis. I mean, it's a wonderful coincidence of timing, but it has really helped them to process probate because they can be done from all the different probate registries and indeed from probate staff working from home. So that is really good news. It's also been to encourage the use of the online application process and to bring in more digital working, which, as I say here, should bring benefits. And it's possibly where the good news gets a bit stuck, because the online process has not been so easy in practice. Any of you who are trying it will have found that there have been a lot of issues, and indeed this very day it looks as though the system is just shut down. It's just not operating today for most people. So that's the aim. Those are the two aims. I've mentioned on this slide, just above my two boxes, that there's a bit of a soft launch. If you are a practitioner who's got a statement of truth you're waiting for from a client and it happens to come in today, you've probably got a 2-week window, because they are going to take, for the next 2 weeks, literally from today, finishing 2 weeks today, they are going to continue to accept statements of truth in the old form. They are not making a big fuss about it. There's no big announcement, but they are, in practice, having this, what they call a soft launch, and that's something they told us on Tuesday. But the aim of the thing will be that now we should all be doing, and certainly from the 1st of June, it'll be the only way you can do it. What I've put at the bottom of this slide, instead of executors signing a statement of truth, there are one of two things. Either, if you use the printed form, it's a legal statement that's part of that form, which is signed, or if you're doing it online, it auto-generates a form at the end, which will then be for the executors to sign. The frustration, or one of the frustrations, is the limit to how much you can do online. There are quite a lot of things which you can't do online, and therefore you have to use the paper form. If the online is impossible, all you can do is go through the form, which is, for us professionals, 23 pages. And a lot of it is very tedious. There's an element of the data processing is down to us. You know, we're trying to save the probate staff from having to do too much data input. At the moment, there is a slight confusion, and do be careful if you look online. There are two versions of the same form, one for personal applicants and one for professionals. Unfortunately, they have the same number. So if you're after a probate one, it's a PA1P form, and it's also called a PA1P, whether it's a personal or a professional applicant. So it is very confusing. And those forms are going to be combined in a few weeks' time, but for the moment, you have to make sure you get the right one. There is a lot of irrelevant detail, and what is relevant and what is not, we can obviously guide on. That's clearly a crucial issue, which we need to look at a bit further. One of the big questions, there's so much more information requested, does it all need to be answered? Well, there are things there that are not needed. Some of it is data, as I said, which is going to save probate staff time, but there are details that are irrelevant. And one of the things they're doing here is getting a comprehensive set of information, so that if there's any issue, if there's an issue with anything about the validity of the will or the witnessing or any of those sort of things, that then the probate registrars have got the other information they might need in that situation. But if we are confident, and if we are dealing with a will and we're confident that it's a valid will and the executors were properly appointed and there's nothing wrong with them, then, as I put in this purple box here, some of the sensitive and personal information may not need to be answered. There's a question about marriages and divorces. You have to, according to the form, you have to go and get details of the date of a divorce and questions about children and how many children the deceased had and are the children of any children who predeceased, which is very much a question for an intestacy. but not for a case where you've got a valid will. So some of those questions do not need to be answered. There is information there, as I've put at the bottom here, that you might not know, you may not want to ask, and the clients might not want to tell us. And so my next slide, I'm just going to affirm here that if there is information you consider is irrelevant, do seek advice and don't rush into seeking sensitive information if you're unsure. If you think there's irrelevant information on the application, spaces can be left blank. There is a box on the online one, there's a box at the very end which explains, you can put in the detail there of why you've left those things blank. On the pro forma form, the printed form, there is a box where you can put in as a professional, if you're acting as a professional, why you left things blank, and explain that. But these information can be left out if we feel it's not needed. I've also put a note here about information on values of assets. In two cases, the values of any foreign assets, if it's somebody who is domiciled in the UK but has got some foreign assets. There's also a question at a different point on the form about the value of assets for a client who is non-domiciled. And some of this looks really tedious, and you think, why do I need to fill in all that information? It seems really unnecessary. But actually the answer is there are technical issues. There may be questions about whether there is a right to issue a grant in the UK, or specifically in England and Wales, to deal with the assets here. And that may concern the part of the estate which is immovables, land and property, and how much of the estate is movables. So those questions may actually need to be completed in order to satisfy the test of what is needed to get a grant of probate. One of the questions that has arisen a lot is, where is the application processed? And this has caused a lot of confusion. In the long run, there is a place at Harlow, which is going to be the destination for everyone. At the moment, Harlow is the place for personal applicants, but it is not for the rest, for professionals, for the rest. If we are professionals, normally we would go to Cardiff if we had a bilingual application. And if anybody out there is looking to do a joint English and Welsh grant, at the moment you should be going to Cardiff, or actually, slight correction, you should be going to Newcastle, because all Cardiff's post is being redirected to Newcastle because of the COVID-19 situation. So actually it's going to Newcastle for the moment. But in the long run, we will all be going to Harlow. But the two main places are Oxford and Newcastle. But all of this is going to be part of one probate registry. It's one united registry for the whole of the UK. And eventually, when it all goes to Harlow, it goes there for bulk scanning, so that it all can be processed, and then it can be sent out to anywhere. So if you have sent something to Harlow, or if you sent it currently to Oxford or Newcastle, and it comes back from Liverpool or from Brighton or somewhere else, don't be surprised. That's because the United Probate Registry is dealing with it in different ways around the nation, and different people are helping out with that process of dealing with applications. So I think we need to get used to this concept of this team across the country working on this. My slide here in the blue box says on date in June to be confirmed, because slightly confusingly, it's the new form, which is the new integrated form that I mentioned, which is going to direct us all to go to Harlow, is not going out just yet. It's still being tested, and it's going to be another 3 weeks or so, probably. So it will be early June, probably. We wait and see, with bated breath. But there we are. We wait to see the new form, and for the moment, we are still working on the interim situation, the continuation, effectively, of the 8-week transition period, which in practice is being extended in the sense that, you know, we're still working on the initial forms until the new one comes out. So there we are. There's still a lot of uncertainty. There's still a lot of things that we yet to establish about how things are working. But I hope I've highlighted and drawn attention to some of the issues as to how things are working and how they're meant to be working. I'm sure there'll be some questions about that, and we'll be pleased to help either now or in follow-up afterwards. But I think the big picture is we've got a new process. In the long run, it's going to help us. It's going to help us because we will have everything digitally. And I was talking to one of our contentious probate partners the other day, and she was saying to me, it's going to be great because if there's any issue about a probate, I can put if I'm putting in a caveat, I can put that in online. I know it's straight there, and there's an immediacy. If you're applying, there's an immediacy. That's the dream. That's what we're aiming for, ladies and gentlemen. We really want to get to that immediacy point that digital communication can provide. Just at the moment, we're still working through some teething problems. And please bear in mind, it's not Owen Mitchell's teething problems, it's HMCTS's teething problems. But we're going to get there. And when we do, it's going to be worth it. But it's just a little bit of, rather a lot of patience probably needed before we get there. So perhaps back to you, Jill, to take us through now.
Yes, okay, thank you, John. We have, as I said earlier, a couple of questions that were submitted prior to the webinar. We've also got one question that's coming during the webinar, so I will run through those now, and I will give an answer. John, feel free to add anything if you wish to do so. The question from yesterday was, what happens if it is not a straightforward application? And in the olden days, you would send in a statement of truth or an oath to the registrar for settling. Well, the difference here is that there is no requirement now to draft the statement of truth or draft an oath as we would have done in the olden days. The requirement is now a legal statement, not a statement of truth. And interestingly, when the probate fees were released, the new schedule released, I think yesterday or the day before, there is no fee on there for settling statements of truth as there would previously have been. So my view would be that you should complete the application form. If it's not straightforward, 9 times out of 10, you're probably going to be on the offline process, so on the paper form, and that you should complete that. As John said earlier, there is a box for you to sort of, speak, I suppose, to the registrar and highlight any issues that you've got and wait for the feedback to come. The only other option I could think of is there is an option to do a pre-lodgement application form with the registry, but possibly to test out the new form and test out the communication via that box on the application form seems the way to go. John, do you have anything to add to that, or?
That makes total sense, Jill. Thank you. Yeah. Okay.
The second question was, how do we deal now with something more complicated like a reseal of a foreign grant, foreign domiciles, and grants for the use and benefit of others, as we would normally deal with those in different ways. I mean, interestingly, for a reseal of a foreign grant, where you were allowed to do that in England and Wales, you didn't actually need to complete an oath or a statement of truth anyway in the old system. And now we have to fill a form in that's very long, and as Johnson asked lots of irrelevant questions. So that needs a little bit of thought, I think. But the good news, really, with the new forms are that foreign domicile is very well covered, as John's mentioned. So there is the facility to give the information you need in the body of the form. There's also the facility to indicate where you might be applying on a use and benefit for basis It asks questions on minor children who might be inheriting, for instance, on intestacy, and who might be acting for them. So I think the forms do cover that quite well, but obviously, as John said, the problem with the forms is they're very comprehensive. They're 23 pages long, and they have lots of questions that in not all circumstances are relevant.
I think, Jill, you made a very good point there, that the foreign domicile element, which is in part 6 of the form for probate, PA1P, is actually is very comprehensive and is very well set out. So as tiresome as it may be to have to give more detail, it actually will help those situations enormously. For the reseals, double probates, those sort of things, there's a part on the form which is in part 2, questions 215 and 216, where it asks what's the type of the application and can you give grounds of application and any relevant information. And that's the box where I think you can put anything extra. And so if you're looking for a special grant, a de bonis non or something else, that's where you'd put all that information. So that is 215 and 216 are the places for that information, and that's our special area.
Thanks, John. The one that came in during the webinar, I think it's a timing issue in relation to payment of inheritance tax and probate, John. So if I could ask you, does the form
the question from Alan.
400, can you see the question? Does the form actually get sent out for signing when probate has been agreed, or is it just when HMRC are happy? I think this is back to your point on the 421 earlier.
I think the process is this, as I see it. The 400, we have to complete that before we apply for probate. We then put onto the application for probate the key information, the end figures from the 400. We then send in to the HMRC the 400 form with the 421 for them to stamp. And then when they've issued that, that's the point at which they say, just simply, we are acknowledging we've had the 400 and we've had the payment. That's what the 421 is doing. It's just saying we've got the form and the payment. Then when the Probate Registry are then get that through the email from the revenue, they're then able to say, okay, the form has got into to HMRC, and they're happy for us now to go ahead and issue probate. So they can proceed with that. It's after that then that any queries in relation to 400 will follow. So the issuing of the 421 is not a sign that the 400 is approved, just an acknowledgement it's been received. But it's the first step. I hope that answers that question. Anything you want to add to that, Jill?
No, I think that's very comprehensive, John. Thank you. Just to wrap up, as I say, there is, if you want to send questions after the event, then obviously there's the email address on screen. And I was just going to mention, obviously we are talking today very specifically about probate and inheritance tax, but in my team, in John and our team, in the tax trust and estate team, we have a whole host of different services, as you can imagine, being a private client team, dealing with everything from wills through to elderly and vulnerable issues, through to our international team dealing with cross-border estates and non-domicile cases. So it's just to explain that obviously this is a small part of what we can offer within our tax trust and estate team at Irwin Mitchell. Also, as well, I just wanted to bring your attention to our website. It has details of all our services on there, obviously not just tax trust and estate ones. And on the top, you'll see the yellow banner going across the top of the website. That is our specific coronavirus hub, where we put all our information on there about a number of different topics that we think people are interested in, either relating to legal services or other issues as well, and it includes things like employment issues and so on and so forth. So do take time to look at that. Some really useful information on there. And the final thing I wanted to say to everyone was this webinar, it has been recorded, and the link for this will be sent out after this event. So if you've missed anything, you can hear us all again. So I think that probably wraps it up. So I'd just like to thank everybody for joining us this afternoon, and have a very nice weekend. Bye-bye.